Microphone check 1 2. Testing 1 2 3. Can you guys hear me okay? We should get going here in just a few moments. So just bear with us here. Welcome, Melanie Rose. Welcome to members. All righty, guys. I'm just waiting for. I have Court TV lined up. I'm not sure how you guys are planning on watching it live, but I'm watching their coverage now. Let's pull that up.
Alter the case before trial. First, he wants the court to reverse a decision by the trial judge that removed his previous public defenders, Andrew Baldwin and Bradley Rosie.
We've had an unexpected turn of events.
Special Judge Francis Gull removed them for gross negligence after leaked crime scene photos were linked to Andrew Baldwin's office.
Journalism.
You guys to start being journalists.
All right, you prick.
Rosie and Baldwin asserted in court filings that Richard Allen
You're the reason for all of
living
this.
in hell in a
Journalism.
protective unit at the Westville Maximum Security Prison. They also accused investigators of lying to obtain the search warrant for Allen's home. That search warrant uncovered the only known physical evidence linking Richard Allen to the.
Yeah, that's the one main thing they want thrown out, right? If he's innocent, why do they want it thrown out?
Buried near the bodies days into the search. Prosecutors say that casing was ejected from Allen's pistol.
What's up, Lynn, Daisy, Big Bird,
members of a white supremacist
Brown
cult
Skittle,
who more likely killed the
Jarmy,
girls
Kristen,
were also
Deb,
serving as guards in
Brad,
Allen's
Ziggy.
prison unit. Allen is also asking the court to honor his constitutional right to a speedy trial and set a new date within 70 days of the High Court's decision. Allen's trial had been scheduled for early 2024, but was pushed back almost a year to give the new
Scremin and
defense team
Librato.
time to prepare. And finally,
Libretto,
Allen wants the High
Librato,
Court
whatever.
to remove the judge, saying she is biased against both Allen and his previous defense team.
There are many dates in a lifetime that you're going to remember. The day Abby and Libby went missing. One of those dates was last Friday, October 28, 2022. The judge did find probable cause for an arrest of Richard Allen. He's been charged with 2 counts of murder for the murder of Abigail Williams and Liberty German.
Richard Allen is accused of killing 13-year-old Abigail Williams.
Right, we'll just put that on mute for a little bit while we figure out what's going on in the chat here. So where is everybody? Are you guys hoping that they get rid of Gull and they bring back Baldwin and Rosie? Or are you just hoping that everything stays the way it is? They should not be allowed back on. I don't think they should be allowed back on. I mean, everything that's happened so far up until this point, I believe, was caused by them. And that's why we are where we are. And that's my opinion.
2022, eventually leading to Richard Allen's arrest.
Okay, and the Indiana Supreme Court hearing now underway. All 5 justices are hearing this case. Let's go into the court.
Good morning and welcome. We're here this morning to hear argument in the case of State ex rel. Richard Allen, relator, versus Carroll Circuit Court and the Honorable Fran M. Gull, respondents. Counsel for Richard Allen, the relator, will argue first. We're hearing this case on a writ for mandamus and a prohibition case. Representing the relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winicky. Good morning, Ms. Winicky, and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana, council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance.
No mic.
Got that. So Matt Gutwein, you're representing Judge Fran Gull, and you will be arguing first. And at council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and counsel. Counsel, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes, so you ready to proceed?
I am, Your Honor.
All right, Mr. Lehman.
Me too, Ziggy.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impied the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes.
This guy's ready.
And his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate.
They're going to see right through this lawyer mumbo jumbo.
Is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that
time to split hairs.
And I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
Oh, you're going to teach the Supreme Court.
Under
Okay.
the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the 3 violations of the Sixth Amendment provide this constitutes 3 situations where in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserve that had preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but
I talked about that.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it for they had it for 2 months and didn't file it. Your client signed it in August.
Swish.
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor,
so basically he waived his right.
Because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with a senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
Hold up.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation.
Not if they're disqualified.
If he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judges. I'm aware of that. I know what's happened.
Watch your tone, buddy.
Tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Bam.
disclaiming no.
You're waiving
Got him.
your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review.
Not a conflict to the court, though.
But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago
didn't get an opportunity
is going
to
contaminate your
They withdrew.
trial.
Counselor, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She found his representation was grossly negligent and incompetent.
She said,
Mark Lehman
Bam.
on the hot seat for now. Then they'll switch up the other side. Fascinating to watch this. This is a great example of why the United States Supreme Court.
All right, guys, what do you think? What's up, Ziggy? Cindy Hudson. Thank you, Cindy, for donating and sponsoring today's live stream. Appreciate that. So it's not looking good here for Richard Allen. He has basically a moot point. Remember, guys, we've been saying it from the very beginning. You don't need a law degree when it's common sense, right? He didn't pick those attorneys. They were court appointed. So right then and there, he has never selected these folks. He didn't have the money to do so. And they weren't offering to do a pro bono from the jumpstart, right? Hell no. But once they became part of this high profile case and they started getting their names out there and everything like that, they didn't want to give that up. The free promotion on this case for them and the advertisement is incredible for them. That's why they came back and said, we'll do it for free. But they effed up. Let's go to the chat here. So far, I think the presiding judge is right on. Judges? He's not doing too good. No, they don't like his language. I don't think they like, I don't know if you want to call it pompous. It's definitely like an arrogant approach. Like, we're going to show you guys what happened. We'll explain it to you. But I also don't like the body language from the justices. He's got his arm like this crossed across his belly, and he's got his and he's talking to him with one arm and the other one tucked. Almost like he's already made up his mind. Yeah, so we'll be back as soon as these commercials finish up here. He picked the wrong ones to go against. He has public defenders, free representation. Yeah, and they were disqualified. So the thing is if Richard Allen, before all of this happened, said, look, I want these guys to represent me, they're going to do it for free. Okay, that's different. But he tried to say that after they were already disqualified. So how are you going to retain a defense team and attorneys that have been disqualified? To me, that's been common sense for me from the beginning. Is the answer is you can't. You want to know why? Because they've been disqualified. That's why. And now we're going right back to Richard Allen's playbook, right? We already know what's next. It's going to be the medical stuff, the medical treatment. Right? This is all part of his defense. He's saying, focus, Rosie, focus, Baldwin. These are what we call runes. Now, according to the Odinite guards, this was part of the ritual. And they're going to kill me if I say anything. So let me proceed and tell all. Like, none of it makes sense. Richard Allen is doing his best to create a narrative that accounts for all of his actions except for being anywhere near the crime scene. That's why he was proactive from the very beginning and came forward. To me, it shows a very high level of sophistication. In comes the new guys. He says, all right, Odinites. Libredo, you sure? We have other options. All right, I think we're coming back.
Welcome back to Court TV Live. We are watching the Indiana Supreme Court hearing for Delphi double murder suspect Richard Allen. The justices are hearing arguments about reinstating Allen's former public defense team, setting up a speedy trial date within 70 days, and removing Special Judge Fran Gull. Let's go back into the courtroom, right where we left off.
The lawyers, I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge just, there's no foundation for the concerns that she's had.
Mr. Lehman,
yes, Judge.
That's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, because she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Balden and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct?
Bam.
Would have gone to hearing.
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action. The judge, I'm going to go out there and I'm going to say these things. And Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more, because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy.
So then why didn't you?
These two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Pick and choose.
correct, Your Honor. I do think I don't think
Got
those
a hearing.
positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth
my
Amendment
concern is getting
requires.
this case back on track.
Yes.
All right. So your argument is that you have
Please.
a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error, it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the
That's
case,
not what
whether
happened.
you go into the courtroom or you stay in here, you're off the
A
case.
lot of events in this case that led up to that hearing, correct? With
Faux
regard to sending information
leaks.
on a case to another criminal defendant, with regard to,
Woodhouse.
well, there's a lot. I don't need to go through it in both
There
your
was
briefs.
leaks from
there's
both
a
attorneys.
lot of questionable things that have occurred up
She's
to this
like,
point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're
not filing briefs, not meeting deadlines, not
filing for a speedy
submitting
trial.
a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that.
All right, Chief Judge Loretta Rush, a little AI reference there. Let's get a break, get you back in for more of this fascinating debate when we return.
All righty, guys. Let's go to the chat here. Nedra Griffin, welcome. No judge has no personal bias. Well, everybody has a personal bias. It's your ability to set those aside. That's what is in question. What's up, Melissa? A nervous probably knows deep down that they don't have the kid. Yeah, he knows for sure. He's just doing his job. He's with what he has, he's doing a good job. You know, he's standing in front of those people who definitely know what the hell they're talking about. I think it's a moot point. I don't think they have anything to argue about. I'm surprised they even looked at it. The only reason they're even hearing this is because it's so high profile. You know, it'd be kind of negligent for them not to. Good to see you, Mustang. Wanda, what's up? They are saying that he wanted a speedy trial. Yeah, and I remember early on that there was an issue with that, as if they were taking actions where they didn't want to go that route. And I think now we're learning exactly what that was, is that Baldwin and Rosie were sitting on that. So I think they were sitting on it as a strategy, not letting the defense or the prosecution know what they were getting ready to do. Are we going to confess? Are we going to ask for a deal? Are we going to drop a bomb? This Odinism thing? You know, you just have no clue. I just don't understand why they didn't just file it. If they feel the narrative that they're pushing with the Odinism and ritualistic killing, and there was a group of people down there, and Richard Allen is, you know, the patsy or whatever, then I think that they would have had come forward a lot sooner, filed for a speedy trial, put out that the Odin report, pulled any of the investigators who thought it was a good theory back then, you know, pull them all out and make it all public. They didn't do any of that. They leaked images. They threatened Gall. And the thing is their actions were always followed by a complaint. So they would complain, let's see, well, they're not making these documents available to the public. Okay, so what follows that complaint? A leak to the public, right? So we don't care what Gall's going to do. We're going to let the public see it anyway. So it was just that whole attitude, very cocky and just very disrespectful to the court. And look at the fruit that came from that tree, right? You had, and I don't know if the mass crime scene photo leak had anything to do with Baldwin's leak, but regardless, it happened. And Rosie also leaked all of the discovery to a known felon who is local to Delphi. And this person was not only local, not only a known felon, but was also had inserted himself into the social media, had a YouTube channel, and had access to all of the players in the social media sphere. You know, he was running around with that information in that realm. So Rosie may have even caused more damage than what happened with Baldwin, because they were able to kind of clean that mess up a little bit. They got law enforcement involved. They got Goal involved quickly. Um, a lot of online sleuths tracked down, the origin of the leaks. Some did, some got it wrong, of course. But let's go back here.
The state Supreme Court is hearing arguments in the Delphi murders case. Defendant Richard Allen is charged with the murders of Abby Williams and Libby German. They were killed back in 2017. He is asking the Supreme Court to reinstate his lawyers and remove the judge, Fran Gull, for presiding over his pending trial. If he gets
Exactly,
his own lawyers
Nedra.
back,
Rewriting history
he's
is what
gonna
they're
want
trying to
speedy
do.
trial and go to trial in 70 days. That's the law. If he doesn't get these lawyers back, it's starting from scratch. Let's go back into the courtroom.
All in conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other. And shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way: if we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but I'm going to change that.
Short answer.
No.
We'll cross that bridge when we get there.
Have nothing to do with effective representation at trial. So I don't think he could pursue him on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery that
hold on, guys,
released over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying
Okay, so I just had to reload this up. Just getting a really bad delay on my end. Pulling it back up now.
There, I think that he would be waiving it. So.
Counsel,
yes.
Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge, or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did.
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that a law that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason. There's an intimate relationship going on, and she pulls them in and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive, you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples, these are good examples of that. In that the inadvertent disclosure,
just the defense struggling,
discovery has not, the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just
could happen all again.
Reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to?
No, I think if there's a concern, say for example, the pretrial publicity, the press release, if you say, listen, I think because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing.
Forgot about the press release.
Let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
structural error,
at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because
if those attorneys come back,
pushed off till
then
October, and
that
when
will
the
be true.
judge said it in October of 2024, one of the lawyers, I believe, even
That's why
represented,
they're
he
gone.
didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the
That's
speedy
what
trial
Goal was
problem, because that
preventing.
was an
That's
intimate
why
part
she
of the
did
trial
what she
strategy,
did.
is to get attorneys Baldwin and Rosie back on the case and get this
protecting
case
the
set for
trial.
trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Okay, there you have it. The argument laid out by Mark Lehman and the questioning from the justices.
All right, let's go to the chat here. Sparky says, dude, everybody's already hurt. Yeah, them being there is hurting the case. That's why Gall had to get rid of them. Everybody's talking about the appeal. There was probably going to be an appeal anyway, right? Regardless of what happened. But if they leave Baldwin and Rosie on, I believe that they'll have a much more of a chance to have a successful appeal. What's up, The Unsolved? He has so much nerve talking about removal, corrupting a trial, when his original defense team literally jeopardized their own client's right to a fair trial by leaking and leaving crime scene pics out. I think his argument is that even though they did those things, it wasn't as damaging to the bottom line of everything. But I disagree. I believe that it was. I believe that it did show that they were incompetent, and that it would have been just a practice trial, right? A practice run, if they would have continued with Baldwin and Rosie. So what these folks don't realize, in my opinion, is that they're arguing a case against themselves, right? There's a flip side. They're showing the Supreme Court a coin, but they're only showing one side. And the Supreme Court's just telling them, hey, look, there's a flip side to that. What you're arguing goes against your own client. And what they're saying is that if they keep Baldwin and Rosie, they go through the whole trial process only for it to not matter at all. And they got to go through it again because he's going to appeal the case. He's going to get the results thrown out based on the fact that even the judge thought his attorneys were negligent. You see, so you can't give this defendant a double-sided coin so that he can use it when he thinks whichever side is best, right? Oh, today I'm going to use heads. Tomorrow it'll be tails. No, you yank that coin right from his hand and you get back to business. See what these guys are talking about.
Someone new is going to be on the hot seat, the attorney representing Judge Gull. Stay with us.
Tonight on Court TV.
No, commercial.
These are the big.
Thank you, Cindy. Hey, what's up, GP? Checking in at the hospital with mom. I hope everything's good for you guys. No word yet. They had Richard Allen's attorneys talking right now, doing a lot of backpedaling. If I was going off the body language, I just don't feel like they're going to agree with them. If anything, they might give him another opportunity for the speedy trial. But then again, why would they do that if he has new attorneys? If he has new attorneys, they're not going to want a speedy trial. And that's why they didn't want a speedy trial to begin with. I remember Baldwin and Rosie saying something like, man, we got so much discovery to go through. It's going to take us months. It's going to take us 6 months to go through all of this discovery. Okay, well, 6 months, that's out of the realm of a speedy trial, right? So, and I don't know if that was part of their strategy to make it seem as if they weren't interested in a speedy trial, only to surprise the prosecution right at the last moment. Like, no, we're going, and that could be true. The Unsolved. This is all intentional chaos to buy their client time. If they keep Baldwin and Rosie and lose, he appeals saying they were negligent. Exactly. So he's going to flip the coin and say, hey, he's going to use it. He's going to use whatever side of that coin when it benefits him the best. However he wakes up, whatever side of the bed he wakes up on. They say it violated the Sixth Amendment. Yep, they have to go. Gall is just there to protect the hearings, make sure this proceeds into trial successfully. She's doing the reason she's there is to make these decisions. She's just doing her job. So people who are talking about a practice trial or, they're doomed during the appeal process, no, because everything's been protected. And unfortunately, in order to ensure that it is 100% protected, we have to wait almost an entire year, right? What, till October or something like that? So because of what they did, Gull was forced to do what she did to protect the trial, to protect the proceedings. Fruit of a poison tree. So anything that stems from it has been poisoned. So you rip it out from the roots and you plant a new one. And you call it the Labrador Screamin'. Oh, looks like we're coming back. The Screamin' Labrador. Or Labrado. Exactly anything I like. I agree. Yep, can't have it both ways. Unfortunately, you got to go.
Welcome back. We've been watching this fascinating back and forth from the Indiana Supreme Court as they hear arguments in the Delphi murders case against defendant Richard Allen. Allen is charged with the murders of Abby Williams and Libby German, who died back in 2017. He wants the court to reinstate his trial lawyers and remove the judge, Fran Gull, from presiding over his murder trial, which is scheduled for this October. Now, Allen's attorneys just finished up their opening. Now let's hear from the attorney representing Judge Fran Gull.
The court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, through the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were
Press release.
Insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers, but it's hard to look at this record and not get the impression that perhaps rightfully so the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
of counsel.
struggling with that. Butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard, in the Knox case, saying a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril, and this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
Yes.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even ask for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage.
You can't punish the judge for doing their job.
Jurisprudence, and frankly, then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So you're also why you think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations of the right to select counsel are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so I'm
violation.
clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case.
Yeah,
in that
not
case,
the
the
same
trial
thing.
court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done. There's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So, did she exceed her authority by the manner?
We need to slip at a commercial break because we're approaching the top.
Okay. So what I'm seeing here is they could go ahead and reinstate Baldwin and Rosie, even get rid of Gall, and go right back into a speedy trial. But they may spend a year. Who knows how long this court process is going to take? So you can spend maybe up to a year trying a case that, like they keep calling it, a practice trial, right? Only to have to run through the whole thing again after an appeal. Okay, so do you want to do that? Or do you want to start fresh where you might be able to avoid some of those issues and just instate a new defense team and start fresh and be delayed a year? Or would you rather waste taxpayer money, time, re-traumatize witnesses and the victims? Or would you rather just put the brakes on, give new attorneys an opportunity to go through the discovery, and then have a fresh start? I think that's the way to go. What's up, Liam? I'm watching from the UK. Shout out to the UK. When is this case likely to get to court? As of right now, I think sometime in October. Will it be arguments like this for the foreseeable future? No, this is something very special and different. This is basically a high court trying to reverse a decision of the lower court. Wanda says the Supreme Court is unpredictable, appearing to agree with both sides. Yeah, they have to. They have to appear neutral, and they have to address the arguments, right? If they see a weakness in the argument, they need to address it. What they're doing is they're getting it out on a record. They're getting it all out there, which Richard Allen's defense team didn't do properly for their client. Instead, they just withdrew and left, and then came begging to come back in using some lawyer arguments. And that's where we are now. I mean, I think Richard Allen has a good defense if he's trying to say that they should not have been well, technically they withdrew, right? So they kind of screwed themselves. So I don't know if the Supreme Court's going to say, hey, well, we don't think that they should have been disqualified. We think that your decision there was incorrect. So therefore, by you insinuating that you plan to disqualify them, they withdrew. So if you put pressure on them to withdraw, and the pressure that you were using, we feel was not justified, then I think they might be reinstated. But I don't think that that's the case. Just waiting for a couple commercials to end here. I agree with that, Cindy. He did his homework a little bit better. Doesn't mean that they're going to side with him, but we'll find out. I think at this point they need to start fresh.
Live more, ache less at tryteeter.com.
Welcome back to Court TV Live, along with Julia Janae. I'm Ted Rollins. Busy day.
Busy day. We're bringing you several major hearings.
It's a good point.
And trials
Anything I
today.
like?
Here's a look at what we're covering. First, in Indiana, the state Supreme Court is hearing arguments in the case against the Delphi murder suspect, Richard.
So we'll wait for this is over. Anything I like says, why can't they have a speedy trial with the new judges? They've been involved since. That's a really good point. And I guarantee that if the Supreme Court rules to just proceed the way things are now with the new attorneys and the new trial date, they're not going to request a speedy trial. Right? It's all just lawyer tricks and strategy and Jarmy Vicious says, hey, most of them likely already know the people responsible. That group is also linked to Flora, the occult, and certain brand of supremacy. That won't be Richard Allen. Well, you're a good investigator. Oh, sorry, guys. Let's go back.
Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period.
Yep, Sparky.
And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no
Coulda,
opportunity
woulda,
to persuade
shoulda.
her. Did I misunderstand?
She could change her mind at
We'll
any
never
point.
know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know because she said then at the hearing on the 31st, what's changed? So, which means
That wasn't her
Well,
judgment,
we won't
though.
know what would have happened at a hearing that never happened, but you're right. I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel,
But she could have.
appreciate you looking out for our original action jurisprudence and our potential future caseload. But as long as we're here, what can you tell me? What can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience.
Intuition.
To find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel capable of making?
I keep getting back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here.
Maybe, Frank.
He wants these attorneys, and so we're spinning and spinning and spinning on this thing, delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney. Get this case back. Let him have his attorneys. He wants to privately hire them. I'm
And do
really
a practice
struggling
trial.
with why he can't make that decision that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that.
It was a major
conflict.
conspiracy with lots of different people playing, in the Wheat case.
Wheat
I don't see
himself,
Wheat is tucked as neatly as you find Wheat. So go outside Wheat and give me something else.
well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But
on...
where can you point to me saying, with regard to saying somebody is incompetent or negligent? That's like, we have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool.
You put Goal in a position to make a judgment. She made the judgment. Now you're questioning it.
Does that rule apply both ways? Because one of the things defense counsel
This
said
will
in a letter
create
to
an
the court
endless
was that they
cycle.
believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that
they don't want a speedy
issue
trial.
Is, I would say,
moot.
Not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel, we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me.
A lot of money too.
Perhaps we don't know, but
waste a lot of money.
Wouldn't that protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you,
Your
Mr.
Honors.
Gutwein. Ms. Sanchez.
All right, let's get a break here as they switch over. Gutwein really relying on wheat, even though the chief.
What about wheat? Damn it. Judge is like, I'm tired of hearing about wheat. Oh, well, that's all I got. That's all I got, Judge. It's all wheat. Yeah, but I mean, they're making a good point. It all stems from them being incompetent. Were they? Of course, we think that because of what happened, and, we always get all worked up about everything. But that doesn't mean that's what's actually happening, right? We know that's why Goal's trying to get rid of them. Hey, these guys are incompetent. I'm sick of dealing with these leaks. You guys aren't listening to me. You're putting your client in a harmful position. You got to go. So I think the Supreme Court might say, hey, well, we don't think it was that serious. And the same way you guys are saying, well, we don't know what would have happened if they didn't withdraw. Well, we also don't know what would happen if we reinstate them. So it looks like Goal's attorney was using his own coin, right? Flipping it when he wanted to. So hopefully the Supreme Court will make the right decision. But I don't want to see them go through the entire process just for them to have to redo it. Because I don't think Richard Allen wants a speedy trial anyway. So even after they make a decision here, he's not going to file for one. Pretty sure. BN Mama feels like it's just Richard Allen stalling. Be a man, confess to the wrongdoings, and take the punishment. No, he doesn't want that. He still thinks he can get away with it. He clearly gives 0 Fs about anyone else, especially the girls' families. He doesn't mind dragging them. Yeah, I mean, think about it. Somebody would have had to have planted that bullet there. It's going to be the first question they ask him. Okay, we've proven that this unspent bullet comes from your gun. We've proven that in a court of law. We're all on the same page. What was your bullet doing there at the crime scene, Mr. Allen? Explain that. What's he going to say? Oh, well, somebody planted it there? Nobody's going to believe that. Wheat. It's all wheat. Just go look at wheat, bro. Jeremy, I'm afraid if this case is delayed much longer that Richard Allen won't survive to see his day in court. That's not a realistic worry. That's why they're keeping him in prison and not in jail. Because if everybody, let's say they do transfer him to a jail where he's right there, 10 miles from his attorneys and 50 miles from his family, and he's right where everybody wants him. And then boom, he commits suicide or somebody kills him. Right? Then what are you going to say? You're just going to complain that they did something wrong. It's never ending with these people. It never ends. And I'm not talking about you, Jeremy. I'm just saying folks who say, oh, well, they're mistreating him. Why is he in prison? Why isn't he in jail? Well, the second they put him in a jail and something bad happens, you're just going to flip the script. So it's almost like arguing it's pointless. Because no matter what, you're just going to keep arguing. You're just going to flip the coin every time. So it's really pointless. What's up, Ruckus? Let's go to Super Junkie. One thing's for sure, some of the accusations against the Supreme Court judges Tomo and Gona be hilarious. The guy will be a Grand Master of the Masonic Nordic chapter of the Illuminatis. It's a lot of Latin. What's up, Purple Haze? I'm kind of confused about that Supreme Court hearing. Do you think they'll reinstate the attorneys? I don't know. I think that they could. I don't think that they will, just because I think it'll harm the entire process. But I think there's been good arguments on both sides.
Welcome back to Court TV Live. We are bringing you the Indiana Supreme Court hearing for Delphi double murder suspect Richard Allen.
The justices are hearing arguments about reinstating Allen's former public defense team, setting up a speedy trial date within 70 days, and removing Special Judge Fran Gull.
Let's get you back into the courtroom. We just finished hearing from the attorney for the judge, arguing with half of the 30 minutes that this side gets. The other half is going to the Chief Counsel of Appeals for the Attorney General's office, Angela Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen's counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case. Unlike here, where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out, and there'll be a hearing, and it'll be done a proper way in the trial court, and then come back up.
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had.
They could just get booted
October
off anyway.
19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the
She's getting to the heart of the matter
and the
now.
fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will
Do you agree that with under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there. If someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state.
He never
that,
picked Baldwin or Rosie.
If those things were
And when
to
he
be
did
the
pick
way
them, they
that
were already
record was.
disqualified.
Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly significant,
default rule,
weighted.
something like it.
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
I'll be right back.
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at if that is in fact what the judge means. I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. Where any one of those incidents in itself might not
But there's no other case out there where a judge sua sponte on her own motion disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with a larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance with counsel cases, and so forth. But it's not the typical language.
Just so I'm clear, you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say no relief today. Is that right?
No, we don't think it's a writ. There's no order. There's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see that my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise a specific.
The attorney for the Attorney General's office there seeming to have a difficult time getting.
All right, looks like they're getting ready to take another break. And remember, if they do reinstate Rosie and Baldwin and get rid of Gall, or keep Gall and reinstate Rosie and Baldwin, there's still positive things about that, right? They get to go back into the trial process. You know, they get to show now that they want a speedy trial. They have to show the courtroom and the world this Odinite evidence that they have and the case that they plan to present. And we don't have to wait until October. So there could be some positives, and it's not all negative. Because it looks like the new defense team's just going to pick up right where the old defense team left off anyway. So if Richard Allen wants them to go the Odinism route, that's the route they're going to go. You can't go against your client's wishes. We're not going to see any change. The defense teams are changing, the lawyers are changing, but the defendant is still Richard Allen. He still wants to go in that direction. He has his reasons. And we've seen his playbook. We know now his next move will be his health deteriorating. His health is deteriorating, and he's losing his mind and things like that. He's being threatened, right, by the guards. We're already seeing that one come. So we already know what his first 3 moves are. This chaos, I believe, is just all part of it. Willow, that's a good point, says she should have made them go through with the hearing and making them look like idiots. Well, she wanted to. That's what she wanted to do, and she was going to. But she hadn't made her judgment. She hadn't made up her mind. So who knows? Maybe she would have listened to what they said and went a different direction. Well, we'll never know because they withdrew. But this court might say, well, they really didn't plan to withdraw. You didn't leave them any other choice but to withdraw. Not only that, you were planning on disqualifying them. That's why they quit. Not only that, the reasons that you were planning to disqualify them, we don't agree with. So I think right now that's the argument. Okay, if they're disqualified, fine. He can't pick disqualified attorneys. But why did you disqualify him? What were those reasons? Were they really that bad? Because I keep hearing them mention the original press leak. They said, oh, well, that was before the gag order. Well, it was before the gag order went into effect, but not before the decision was made. So I think that is the argument right now. What do you guys think? Yeah, I don't think she was trying to save them from embarrassment. I think they were trying to save themselves from embarrassment. And this is them picking up the pieces. They know this case isn't a winner, but they want to go through the process anyway. Who would threaten them, Jeremy? The unsolved. All the AG had to say just now is it would set them up for Allen to claim a mistrial. This is such a clusterfuck. Well, the thing is, too, you don't want to be disrespectful by kind of telling the Supreme Court the obvious. I think they're playing this fine line of skating around, not telling them how to do their job while presenting their own case. But I think there's a lot of times where they could say certain things, but it would just be kind of like a jab at one of those justices by stating the obvious. You know, they know that the reason you're in the Supreme Court is because they're past all of that. They're getting right down to the fine detail of it all.
What Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Galt, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr.
Calm down, buddy.
With respect to
Take a deep breath.
court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what their ethical rules require them to do, which is to give you
they don't want to do a pro bono anymore.
And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and
they
said,
want to be
listen,
reinstated by the court.
He's been clear what he wants.
Not pro bono.
This is what we're willing to do in order to protect.
That's not a good look, fellas.
But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of
he
what
went
his
too far.
expectations were, and that I want these gentlemen to see this case to its end.
They'll be denied.
The attorney general and the judge want to
he
create
just took it too
ambiguity
far.
where none exist. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is. But I think that
well, you don't have a choice.
Alternative there falls short. With regards to Wheat says
he has a good point,
where
though.
a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest
should have asked for that later
than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial.
Then they leaked it to the public.
So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as WEAK's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Masson, Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client, trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being relating to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes.
That's the real question.
If these things could ever arise, the ineffective assistance of counsel
Thank
and
you, Athos.
justices, I'm not conceding that. But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick's
Jurisdiction.
when she
They
had
didn't
an
like that
absolute
word.
duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to
Frank.
recognize what he wanted, go forward with trial in January, and this case should be heard
To
in
eat their
Carroll
wheat,
County
son.
today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you,
I don't
counsel.
know.
I wanna
Lehman might have done it.
commend Counsel on both sides, just
I
excellent
don't know if they'll
briefing,
get rid of
excellent
Gall, but they
argument.
might
We'll be
reinstate
discussing
Rosie.
the
Rosie
case
and
and getting a
Baldwin.
decision as quickly as possible.
And that wraps up the arguments in front of the
All righty, guys. That is going to do it. We'll hang out for another 5-10 minutes. That way we can kind of unwind and see what you guys think about everything. I find the good in anything. If they reinstate Baldwin and Rosie and even get rid of Gall, we're back on track, right? They can go ahead and they can go to trial and present their case. Is that good for Richard Allen? Hell no. I don't think anything that those guys have been doing for Richard Allen are good. But that's why I could never be on a jury, because I don't give a shit about Richard Allen. I feel like there's a really strong case against him. I don't think he's guilty, but I'm not worried about what's going on there. I feel like they have their man and they're going to prove it. So I have no qualms about that. So if this is the way they want to go, I don't think that it benefits Richard Allen at all. But he's up to something. He needs attorneys that he can use. He's doing something. This may even be like some kind of a veiled confession, because even with an Odinist theory, that doesn't eliminate Richard Allen from being a part of that, right? You got to get him out of there. You got to show that not only that the bullet belonged to him, but that somebody planted it there. And that's a huge leak. How's he going to explain that in a courtroom? And then also the defense is going to have to prove that there was a whole group of folks down at the trails when they couldn't even find Richard Allen. It took us 3 years to find somebody that was at the trails that nobody had mentioned. It took us 3 years to find somebody. So where is this group? Where is this cult ritual that apparently is for at least 4 individuals? I mean, I guess they could have all pulled up in the cemetery, hiked out, and got back in a vehicle. Guess that's not out of the question, right? Excuse me. What about wheat? So I don't know. Maybe no matter what, we were always going to see a retrial. So either way, the quicker we start, the quicker we get those answers. But I think overall, reinstating them is just too harmful to the process, which is in turn is harmful to the victims and the defense. But like I said, Richard Allen just wants somebody that he can control. He needs a defense team. That's why he wants Baldwin and Rosie. He's probably already comfortable with the new team, and this has all just been a waste of time. Like, oh, you guys are going to do exactly what I needed them to do. Well, we'll see what happens. He's just there to waste time, create chaos. This is and somebody put it in the comments. This is his power. This is the only power he has, is to create chaos. And a lot of these defense attorneys are willing participants. I mean, think of the advertising. You sure you want to go that route? All right, that's on you, buddy. Either way, we're good. We'll even do it pro bono. Nothing's for free, right? All right, so let's give a shout out to Melanie Rose. Welcome to the Sleuth Crew. Make sure you guys give her a warm welcome. Cindy Lean coming through with a fat $10 super chat. Willow Rain, Farmer, and Hathers. Thank you guys for sponsoring today's live stream. Shout out to Court TV for getting in there and live streaming that for us. That's a good point, Ruckus. Either way, the evidence doesn't change. And if the defense is going with the Odinism thing, hey, they got an uphill battle, right? But I have a feeling Richard Allen does not care either way. He has a plan, and he's not going to share this plan with anybody. It may even be some type of veiled confession or some kind of veiled effort to snitch on the other folks who helped commit this crime without just coming right out and saying it. But I doubt that. Remember, if Richard Allen's the same guy who staged the crime scene and he's the one that made it look like a ritual, then wouldn't it only be his next move, once arrested, to bring that up? Like, you guys can see that this is a ritual, right? But it's almost like, if it's not that hard to make a ruin, right? We've seen what they are. You need 3 sticks to make a clear ruin, and all you got to do is make it clear. The crime scene is not clear, but maybe this dude is just such an idiot. He thought it was clear. He was trying to make ruins, and he was trying to mislead investigators for whatever reason. And then he had 6 years to come up with this plan. Once I get arrested, this is what I plan to do. I'm going to introduce them to the Odinism stuff, because I know exactly what that crime scene looks like. But me personally, that when I look at what they call runes and that F on Libby's tree and all that stuff, I'm not sold on it. And I could be wrong. I mean, what the fuck do I know? But if you want my opinion, I'm not seeing runes. I'm not seeing rituals. I'm seeing a personal relationship to the victims. I do see that. I'm seeing a rushed crime scene. Somebody who most likely felt a little remorse. I mean, if you didn't, why even worry about it? Just get up and get out of there. I see somebody who needed to buy time, and whoever staged that crime scene, which I think is most likely Richard Allen, bought themselves an entire day, almost like 23 hours to come up with a better plan, right? Because if he would have just left them there, there's a likelihood that one of the victims was on the south side of the creek, maybe even exposed on the water, and all the people that we know that were coming around the bridge around 3:45. We know that Cheyenne snapped a photo and it had a timestamp. So if she's on the south end of the bridge, that tells me that Richard Allen is now feeling rushed, and is most likely the reason why he is spotted less than 10 minutes after that on the 300, apparently bloody or muddy. Let's just say he doesn't even have to be muddy and bloody. So he's already taking pages out of his old playbook, right? So we have the Hannibal Lecter. And then we have these photos. Hold on. Right? I think this is page 2 out of his playbook. Like, this is who I really am, and this is what you turned me into. Hannibal Lecter. Ajarmi. The group is known as the Vinlanders. 3 of them live in Delphi. Yeah, we talked to Patrick Westfall. He might be a bad guy. I don't deny that. But does that make him a killer of Abby and Libby? Was he there that day? Thanks, Cindy. Just put some wheat in the cassette section of the Discord. All right. That's a good idea. Your Honor, but wheat. We're going back to wheat. All right. She said, can you show me any other examples outside of wheat? No, Your Honor, I cannot. Crazy thought. Yeah. It's a good idea, Willow. We'll throw it in the Discord. Yeah, what if? Imagine telling a story like that to a jury and you're facing the death penalty. I hadn't touched it at all since 2000. That's when I bought it. And then it was stolen. And then the real killers put it back. If I was a jury, I ain't believing that shit. That's crazy, V. It's probably the manna they talk about in the Bible. Sleuth, can you imagine after all this, at the last minute, he changed his plea to guilty? I don't know. He's got something planned. I don't know if this is like part of an insanity plea, maybe. But he has to set it up properly in order for it to work. He's definitely going through the motions. A word from our sponsors. Wheat. Thank you, sponsor. Frank says, no, yeah, it's a stretch. I mean, this whole case is a stretch. That's the whole thing about it. But I just don't think any jury's going to buy that story. I don't think they're going to buy this Odinite story either. And that makes me wonder, does he even care? I feel like he has something else planned. Insanity plea, or he's going to confess and say, but the real, the main killers are these people. Maybe that's why they can't keep him in a normal jail. Maybe some of the other people involved are working within the jail system. All right, let's go to a couple more comments. Let's go to Lorraine Perez. Does Richard Allen get to choose his public defender? No, he doesn't. If so, if we're ever in his shoes, God forbid, will we get the same option to choose our public defender? No, you don't get to choose your public defender. Leslie says Richard Allen had a long time to plan what to do if he got caught. And that's what we're seeing now. We're watching that unfold. He for some reason he has to lead to the Odinite thing because that's probably what the crime he left at the crime scene. But in order for him to acknowledge that he knows anything about Odinism, somebody within the prison, like the guards, had to come up to him and threaten him and tell them, we are Odinites. We are the ones who are responsible for the murder. And if you say anything, we're going to hurt your family. So that's how he's aware of it. So it all has to fit. He's telling the story. And right now we're back to chapter 1, page 3. Alrighty, I think that's going to wrap it up. We're all caught up on the chat for the most part. What's up, Anthony? Good to see you. V. Marie, thank you for modding it up today. I am smelling a Lee Harvey Oswald. Well, you put him back in that jail. He's probably going to hurt himself before anybody else can get to him. That's why he looks like Hannibal Lecter. They're afraid as soon as they let him loose, he's going to grab a pen and stick it in his damn neck. Alrighty, guys, that's going to do it. So if you are part of the replay crew, let me know what you thought about today's live stream and what you thought about what was going on in the Supreme Court there in Indiana. Leave a comment. Let me know what you think. And I'll be meeting with you guys a little bit later today. We will have another live stream. I'm working on something for you. It'll just be a quick Sleuth Crew check-in. And keep an eye out for that notification. Have a great day. Peace.